24-1-130234 and 24-1-132534, State versus Ali. This matter is before the court today. The evidence has concluded in this case, and the court needs to address appropriate jury instructions. Ms. Stone and Ms. Zoe are present on behalf of the state. Mr. Kading is present with Mr. Ali, representing Mr. Ali, and Mr. Leary is present with Mrs. Ali and representing Mrs. Ali. Yesterday afternoon, after the conclusion of the evidence, I provided to the parties draft instructions and explained kind of how I put those together. I would just indicate, in case there's any questions, the copies I gave to the parties were double-sided. The original instructions will not be double-sided. I do run instructions continuously, i.e. not a single instruction on each page, but I will never break up an instruction between two pages when the final instructions are put together. As to, and as I refer to numbers, I am referring, of course, just to draft instructions, but I'm not going to repeat the word draft over and over again. So as to instructions 1 through 3, any issues with those? And I don't know if Ms. Stone or Ms. Zoe are going to be dealing with issues related to jury instructions.
I will. I'm sorry, Your Honor. May I remain seated while we have the conversation?
Of course.
Thank you. No issues. What's 1 through 3?
All right, Mr. Kading.
No issues, Your Honor.
Mr. Leary.
No exception.
All right. Number 4. The state and Mr. Kading submitted the same instruction. Mr. Leary submitted an instruction that has bracketed information from the WIPIC, which includes what is often referred to as the abiding belief language, the last sentence. And I have that bolded in the instructions so that it would be clear that that was the issue that I would be addressing. Mr. Leary, I thought I would hear from you first.
As I'm sure everybody is well aware in terms of the arguments associated with WIPIC 4.01, it is not error to include that language. It is discretionary as defined by the comments and by the bracketed material in 4.01. I do object to language where the court is directing the jury as to whether they are satisfied beyond a reasonable doubt. I would also note that in the introductory instructions that the court provided to the jury when discussing reasonable doubt, the court did not include the abiding belief language, which I did note. Would ask to be consistent and simply I object. And I'm not aware of this court's policy, and I know that courts generally have a standard policy, so that's my argument.
Thank you. Mr. Kading, your instruction did not include that language.
Mine did. The abiding belief, I believe, is it. It did not.
I don't think so, but I could have missed it, certainly. I'm looking at your initial instruction, and you included the abiding belief
I don't
language.
object to it. I mean,
Okay, because that's what was in your proposed instruction. Yes, so that's, and I apologize if I wasn't clear. You did propose that language?
Right.
Yes, all right. And that's why I indicated on the draft instructions that it was only Mrs. Ollie's instruction that had that language. Ms. Stone?
Thank you, Your Honor. Your Honor, I think counsel is correct as to the law regarding the abiding belief language. That is discretionary for the court. Obviously, the state would note that that language is regularly given. It is appropriate to give that language. The state's position consistently has been when we are talking about reasonable doubt, that is not a objective measurement that the jury can look at information and say, it's this percentage, there's no numerical value. And while we talk about it regularly as attorneys, especially as criminal attorneys, in the course of the law, that has become, I would argue, a very, we have much more familiarity to it. The first time that most jurors hear that as a measurement for deciding a case is during the course of the actual case when they're on jury duty. So they don't have that same familiarity. The state's position is and will remain that by giving essentially the opposite side of that coin, that helps the jury decide what otherwise could be I don't want to say amorphous, but a oftentimes difficult standard to apply with any level of certainty. So by giving them the opposite of of reasonable doubt with abiding belief, that is the opposite side of that coin, that helps give them another means for discussing with each other if they have a reasonable doubt. I would ask the court to provide that as additional definition for them to help them make that consideration. It is appropriate, it is not error, and I think it is helpful to the jury.
Thank you. Anything further, Mr. Leary? All right. First of all, Mr. Leary raised the issue as to when I gave my opening information to the prospective jurors, to the entire panel, I give them what I tell them is a definition of reasonable doubt. And Mr. Leary is correct. I did not read the abiding belief language, and I don't ever include the abiding belief language when I give that just general definition to a jury. These are the jury instructions, which are different than the court giving a jury a general idea of how reasonable doubt is defined. And I would posit that no one will remember, first of all, exactly what I said at the time of those instructions. The reason I don't give the abiding belief language is that I don't want someone who is a defendant to feel that they cannot suggest that if I give it, that means it will be in the final instructions. I want both sides to have an opportunity to argue that to the court, and so I don't want to read that on the off chance that someone would remember that they heard it differently. That's why I don't include it. It allows both sides the opportunity to argue to the court at the time of instructions whether or not I should include the abiding belief language. And I don't like to have a policy as it relates to jury instructions, as it relates to how I give jury instructions. I don't think that's appropriate. I think the court has to decide every time what are going to be the appropriate instructions. In this matter, I find, and as the lawyers have properly indicated, if the court includes the abiding belief language, according to our pattern instructions, that's appropriate language and consistent with the law. If the court did not give the abiding belief language, that is also an appropriate instruction and consistent with the law. I am persuaded that it is appropriate, and I will include the abiding belief language in instruction 4. Any issues with 5 through 7, Ms. Stone?
No, Your Honor.
Mr. Kading?
No, Your Honor.
Mr. Leary?
No, Your Honor.
Ms. Stone, any issue with number 8?
My question, if it was necessary, Your Honor, in terms of the state going back through the evidence, I saw statements obviously that Mrs. Ali had made, which had come in, and statements that Mr. Ali had made, or I guess not made, but referenced in terms of arguments between his daughter and students at the scene, but not as it relates to each other, or that necessarily discussed the actions of each other, as the state's position is that Mr. or Mrs. Ali did not reference really her husband's actions at all. Her husband was referenced only in terms of what people were doing to her husband. So I don't think that it's necessary, and I think that it could be confusing to the jury in terms of how they identify what is happening in the case. That instruction number 8 is essentially a rule to address Bruton, and we don't have those two statements here. There's no confession statement that implicates their co-defendant in terms of behavior. So I think this instruction number 8 is confusing, and I don't think it fits in this case, even though it is a co-defendant case.
All right, thank you. Mr. Kading?
And Your Honor, I don't know what the final argument of the government is gonna be, but I think that this instruction is necessary, because I know there has been references to statements she made, after this event that the state has been eliciting from the witnesses. Obviously, Mr. Ollie was part of those.
Bless you.
So I think it's appropriate to limit, the statements that she made to be, used in arguments in case, against her, but not against Mr. Ollie. So I would ask the court to include it.
Mr. Larry?
Well, I can think of one example. One, I think it was Officer Bell, said that Mr. Ali told Mrs. Ali to just go home. Given that my client is charged with burglary and the argument that she had been trespassed, that statement shouldn't be used as evidence of the burglary or trespass, and that as to why. I didn't get a chance to cross him on why he wanted her to go home, because she wasn't supposed to be there, or just because the event was over and just go home. I do think that instruction is appropriate.
And so I'm not making that argument, so insofar as that's helpful, I don't think that applies. That burglary plainly was committed prior to that statement being made. So I understand that concern. That's not an argument the state's making, or would make, and I don't think that makes that instruction applicable, I guess. My concern is that Mrs. Ali describes what she sees as it relates to what is happening to her husband. My concern is that whether the jury looks at that and says, well, then do we need to take what Mrs. Ali said she says and cut Mr. Ali out of those observations altogether, even though it doesn't address any behaviors done by Mr. Ali. In fact, it's completely silent as to behaviors by Mrs. Ali, or excuse me, Mr. Ali. So that's my concern, is that it is going to be confusing to the jury in terms of how they apply it to Mrs. Ali's statements about her husband.
What specific statements are you concerned about would be confusing to the jury if this instruction were given?
Yes, Your Honor. My concern is that the way it implies is Mrs. Ali very specifically says she rolled up, she doesn't say roll up, but she and Haneen arrive on the scene, and that she is watching a student beat her husband. They're punching him over and over and over again. Those were the statements that she continues to make. My concern is that the jury, in reading this instruction based on essentially the nature of it, that somehow then they have to pretend she doesn't say Mr. Ali and it's just a person or someone else. That they shouldn't use it that way, but because of the way that it reads, my concern is that somehow they will neutralize and take Mr. Ali out of that statement by Mrs. Ali, even though it's not attributing any actions to Mr. Ali, and there's no statements regarding a confession or conspiracy whatsoever. So that's the state's concern. I don't think it applies in this case for those reasons, and I think it can be confusing to the jury.
Mr. Larry?
The state said that they weren't going to argue, but that's not the only standard. You are telling the jury how they are to weigh the evidence and how they may use the evidence. And just because the state doesn't make an argument with respect to the burglary, it doesn't mean that the jury might not use Mr. Ali's statement.
All right. I am going to give instruction number 8. I think it is appropriate under the evidence that has been presented in this case as it relates to statements by the defendants. I do not believe that it's going to limit a state in how they can argue their case and the facts that have been presented in this matter as it relates to each of the defendants. Instruction number 9, the last clause of that instruction or of a third person was included in the instruction offered by the state and Mr. Kading. That clause was not in the instruction offered by Mr. Leary, and it appeared to me that it doesn't apply.
The state agrees with Mr. Leary's instruction, Your Honor.
All right, Mr. Kading?
I do too, Your Honor. I only included it because it wasn't bracketed, so I agree it's not relevant.
So what I have bolded in the draft instructions will be deleted. All right, Ms. Stone, any issues with 10 through 12?
Only on 10, Your Honor, I would indicate, I think we need a, he or she does any act that is a substantial step.
All right. If I add or she, any issue with that instruction, Mr. Kading?
No, Your Honor.
Mr. Leary?
No, Your Honor.
All right, and I didn't ask you, any issues with 11 or 12, Mr. Kading?
No, Your Honor.
Mr. Leary?
No, Your Honor.
All right. Any issue with number 13, Ms. Stone?
No, Your Honor.
Mr. Kading?
No.
Mr. Leary?
Yes.
All right.
So I guess at the outset, as evidenced by the pretrial brief and representations, the state had previously indicated, despite what was in the amended information, that they were not proceeding on an accomplice liability on the murder. I reached out to the state after I saw their draft instructions to say, had that position changed, or was this included in error? And they indicated that they did intend to offer this with respect to the attempted murder, and the specific explanation was based on Ms. Wagner's statement as to the actions of my client in terms of that she saw mom striking the man. And so her testimony was different from that, but regardless, I don't believe that there is, so I just want to be clear that the accomplice liability applies to the attempted murder, is that correct from the state's
Yes.
perspective? And only the attempted murder. So operating from that, so
No, I mean, she's charged as a principal or accomplice several times. If we're talking about the attempted murder, which I understood the question was, then yes, it applies to the attempted murder, and she has been charged that way consistently. I think that there are two theories that the jury could apply it on, either as a principal or as an accomplice, but both of those are available to the state. And while we did discuss very much earlier on in the case, a different scenario that much later in the case, as we talked about it, Mrs. Wagner's information is different, and I think the testimony at trial is consistent with the charging, and the state intends to argue that as well. I think there's two theories that the jury could find that on, based on the testimony that has come out at trial.
I think we're on the same page.
Okay.
I wanted to be sure that I was only talking the accomplice theory, in addition to the intentional theory on the murder too, is the only, the count of attempted murder is the only account where the state is proffering an accomplice theory, not the assault two or the unlawful assistant. Is that correct, or am I incorrect?
I think counsel is incorrect. I think that
Okay.
both of those apply. I think the stronger argument, certainly for both of them, for the state is the principal, but I think the accomplice liability applies for both. The state would be arguing both of those as charged.
Okay, that's helpful, thank you. So, the question then becomes, in the instruction, is there sufficient evidence for the jury to consider my client as an accomplice? And I will start with the attempted murder too. If we look at the video, we know that in Exhibit 34, you can see at 213, you can see the Honda Element going the opposite direction on Mullen Road from the bus. And It then turns, the bus then parks, and then the Honda Element turns into the parking lot. The Element is already turning into the parking lot while the initial physical confrontation between Mr. Ali and Isaiah Williams by and can see the initial confrontation. So she then pulls into the parking, actually Haneen pulls into the parking lot, and on exhibit 114, which is the Timberline High School video, we can then see her running across the parking lot, and there's been no testimony as to what is visible from there. We can surmise the distance. We know there are cars that she's running around, and that there are kids surrounding Mr. Ali, Fatima Ali on the ground. We then look at exhibit 89, which was discussed yesterday, admitted earlier in trial, which shows the arrival of my client standing next to the truck with the large Douglas fir tree in the middle of that still shot exhibit. So we know there's been no discussion about a conversation between my client and her husband about solicitation, a direction, commanding, encouraging, or requesting Mrs. Ali to commit the crime of attempted murder. There's no testimony that she agreed to aid in the planning of the commission of the crime. So the sole question is whether or not she aided Mr. Ali in the allegation that he committed attempted murder. We know that mere presence and knowledge of criminal activity, so more than mere presence and knowledge of criminal activity must be shown to establish that a person who is present is an accomplice. That's in the instruction. So, and then there's case law that talks about, it's not should have known, it's that they actually knew. Now, the state has made a large effort, or has addressed this topic repeatedly, that at no time did my client tell the police, talk about strangulation, or talk about or seeing her husband strangle Fatima. She talks about the repeated punches to his head over and over and over again. Furthermore, the court is well aware of the positioning of everybody. So we have Mullen Road, we have Fatima on the ground, we then have her dad either on top or laying in between Mullen Road, so Fatima, Mr. Ali, and the school, the direction in which she's coming. There's been no testimony that, in terms of what was visible from the parking lot, there's no pictures or evidence that detectives went afterward to basically show what is visible from the parking lot. There's nobody said it was very clear from where I was standing next to the truck or between Mr. Ali and the truck that it was very clear that what was happening. What she says is, I could see him being struck in the head by Isaiah. So the state has to prove that she has actual knowledge that he was attempting to kill her, and that she then, with that knowledge, agreed to assist in the commission of that crime. And there simply isn't sufficient evidence for the jury to be instructed on attempted murder 2 as to attempted murder. So then the next question is, as to assault 2, with respect to strangulation, same argument. She comes up, and we know from Mr. Wagner's arrival, he comes from one side where he can actually see Fatima, intervenes, and his testimony is Dad immediately, he removed Dad's arm with some force, but there really wasn't much of a struggle, and he basically was able to immediately stop Mr. Ali and the actions of Mr. Ali. So then we go to the unlawful imprisonment. Now, the court noted yesterday in the halftime motion that strangulation isn't a part of reasonable parenting. But we have to look at it, again, from the eyes of my client. She sees, presumably, we don't actually even have testimony that she did see, or could see, or made eye contact, but there's an argument, circumstantially, that she was able to see her husband and able to see her daughter as they passed by the bus stop on Mullen Road. And the video, 34, there is nothing that's happening at that point. There's been no physical struggle, there's no punches, there's no strangulation. So she pulls into the parking lot, she knows presumably where they are because that's where she ran. There's no testimony that anything that happened beyond those kids is visible. She then runs through cars, sees arms punching her husband's head, goes into the crowd, same time Wagner stops Mr. Ali. She then grabs her daughter. So in the split second that this all happens, mere presence and knowledge of criminal, more than mere presence and knowledge of criminal activity must be shown. If we're talking also about, self-defense, we talk about mistaken belief, right? Which is a somewhat analogous here. There's nothing to suggest that he says, I'm going to kill my daughter, and that was the purpose of going to the school. So there's nothing to suggest, again, that solicitation, command, encourage, request. The only issue is whether she aided him in attempting to kill her daughter in the fraction of a second where she arrived with Mr. Wagner and he diffused. There isn't a basis for accomplice liability. Now, the state is also arguing, and I'm not arguing for a halftime motion, as that the actions of my client as she's holding her daughter, the state is alleging assault too for that, and unlawful imprisonment. And I'm prepared to argue to the jury against that, but to say that she is an accomplice to what happened before she arrived, and in the fraction of a second that she's there, I think is an abuse of the accomplice liability statute and legal theory.
Just one moment. All right, Ms. Stone?
Thank you, Your Honor. Your Honor, counsel, in his argument, says that she sees her husband being punched repeatedly. We saw that from the arguments, the body cam video of Mrs. Ali's statements that she sees her husband being punched repeatedly, over and over and over again. She in fact demonstrates that to Officer Chavez over and over and over again. Those punches can only be happening while her husband is strangling her daughter. Josh Wagner, who quite plainly gets there after Mrs. Ali, that is on video. That was also what Mr. Leary just indicated in his argument, because that's consistent with the video. Mrs. Ali arrives not long before Josh Wagner, but just before Josh Wagner. Josh Wagner, who knows none of these individuals from Adam, immediately says, as he's walking up, he can see that this man is strangling a young girl. Initially, as he stopping his vehicle, he believes it is a group of kids fighting another kid. He says as soon as he's out, he can see that it is a man strangling a child. Mrs. Ali arrives at that scene just prior to Josh Wagner, not long prior, but just prior, and instead, she, who knows both of the parties, she obviously knows where she's going to get to that bus stop in the first place, so she has communicated with her husband in some way. That is the state's argument, because otherwise she has no way to know to go to the bus stop from where she is sitting, even by Mr. Leary's own argument, out in the parking lot, if that communication has not happened. So of all the people there, even if she knew none of that, she knows who those individuals are. And so everybody there who doesn't know anyone else from Adam clearly sees and testifies immediately that they can see a grown man strangling a child. Mrs. Ali arrives on scene, and instead of assisting her child, immediately starts pulling and striking children that are there to get them away from her husband. And all of her concern is about her husband. So she's already on the ground at the time that happens. She absolutely is an accomplice to that attempted murder. She is not helping her child. Counsel can make the argument that he doesn't believe the accomplice liability theory applies, or that the state has not met that burden, but all inferences should go in favor of the state, all of those reasonable inferences, and it should be provided to the jury to make that assessment themselves. Certainly she is more than simply on scene and present. That application actually in this case would apply, I would argue, to the kids who are videotaping, to the people who are watching and don't know what to do, not Mrs. Ali, who immediately jumps in, inserts herself, and is not there to assist her child. It does not appear based on the testimony that we have received. So the accomplice liability absolutely is appropriate for the unlawful imprisonment as well, because then immediately upon being released, despite all the information to the contrary from the spectators, she immediately goes into choking her child as well as restraining her child while her child is trying to get away from her, in exactly what everybody else says they saw and that she was there at the same time to see. Everybody identifies that after Josh Wagner does whatever Josh Wagner does to restrain Mr. Ali and have Fatima released from Mr. Ali, all striking stops. That is consistent with the video. So if Mrs. Ali is there to see repeated strikes over and over and over again, then she is also there when that strangling is happening of her child, and she knows those parties better than anyone else. So the accomplice liability absolutely should be given in that case.
Mr. Lurie, anything further?
I'll leave it up to the court, but I would encourage the court to go back and watch the short clip in 34, where you see the arrival of Mr. Wagner and you see the arrival of my client. If you have questions as to the representation of to what my client did and what appeared to be visible to her.
All right. Certainly the court viewed that clip, which I believe was played multiple times during the course of the trial, and so I'm familiar with what I saw during the course of the many playing of that video, and I would posit that I saw more and more as I watched it time and again, based upon the questions that were being asked of any particular witness who was viewing that footage. Certainly as it relates, the information, which is not ultimately controlling as it relates to the jury instructions, it's whether or not there has been evidence presented, if with inferences, with reasonable inferences to the state, whether or not an instruction would be given, even regardless of how the matter is charged within the information. I find that there is sufficient evidence when I view the evidence with reasonable inferences to the state for their arguments of accomplice liability as it relates to Mrs. Ali. As has just been argued on the attempted murder charge, the assault in the second-degree charge, and then I don't, if you want any further argument as it relates to the unlawful imprisonment, but I also would, it's all of those things are linked together in the time frame, and so really I find that there's sufficient evidence with all reasonable inferences for the accomplice liability for all three, for the attempted murder, for the assault 2, and for the unlawful imprisonment. And so I will be giving instruction number 13. On number 14, the WIPIC indicates that when there's attempt, that there needs to be an elements instruction separately delineating the elements of the crime. The state proposed number 14. When I viewed that, it appeared to me that the last two paragraphs in the proposed instruction are not appropriate because only the elements, by my reading of WIPIC 100.02, should be included in that instruction. So, Ms. Stone?
No objection to that, Your Honor. State agrees with that deletion. I would also ask, essentially, anywhere it says FIA at this point, we just, based on the way the testimony came out, that we just change it to the name Fatima Ali, and date of birth obviously isn't needed, excuse me.
And
And
so-
that will be throughout the actions.
All right. Mr. Kading, as to instruction 14 with the suggestion that the last two paragraphs be deleted. Up in the first paragraph, it still says the elements would need to be proven beyond a reasonable doubt, so that is still part of the instruction.
Correct, and I agree with the court's analysis on that.
All right, Mr. Larry?
I agree with the deletion of the last two paragraphs. I have no objection to using Fatima Ali. I would object to the inclusion of her birthday, because I think it's a comment on the evidence to establish her age.
No, I said not to include it.
Oh, so if the court didn't go with your suggestion, I would note an objection. And then with respect to element 1 and 2, it says a defendant. I would ask that it say the defendant. My concern is that if they were to convict one defendant, it would necessarily result in the conviction of the other.
Ms. Stone?
I don't think I have an objection to that.
All right. And Mr. Kading, any objection to me using the name Fatima Ali and removing the date of birth?
No, Your Honor.
All right. Any objection as it relates to the defendant versus a defendant in elements 1 and 2 of instruction 14?
No.
Any exception on 15, Ms. Stone?
Yeah, and I think it needs the principal or accomplice language in element 1, that the defendant, that on or about October 18th, 2024, the defendant, and then I think it should be inserted, comma, as a principal or as an accomplice, comma, and then did an act that was a substantial step. So I think that language needs to be inserted in there.
All right. And this was your proposed instruction?
It was, yes, Your Honor, it just got left off.
All right. And so, just so that I have what your proposal is in full, after the word defendant, as a principal or as a accomplice?
Yes, Your Honor, both of those set within commas.
Okay. Mr. Kading?
Now I'm confused. So are they alleging that the defendant, Mr. Ali, was an accomplice to his wife's actions?
It's
This
charged,
is
I
his
think.
instruction, right?
It is his instruction. I think that it is charged that way. I think that the state is alleging it the state is alleging it as a principal, but I also don't want the jury to get confused when they are listening to Mrs. Ali's, that somehow you have to decide that one person is something more than the other person. And I think that that language is appropriate in that, because it is irrelevant in terms of if for some reason they believe that he is an accomplice over a principal based on the information, I don't want them to get tied up in that language. So that is an appropriate statement, and the state is arguing primarily that he is a principal, but that there is a concert of action between the two of them at the time these events are going on.
Mr. Kading?
And Your Honor, I don't know, based on what we've seen, how his actions, which were his own, he then is laid flat on the ground, not moving. If there's an allegation then that she did something, I don't know how he's an accomplice to what she's doing. Similar to what Mr. Leary was arguing, except my client being there and prostrate on the ground certainly has nothing to do with what's going on with Miss Ali behind him.
All right, anything further, Ms. Stone?
No, Your Honor.
All right, I am not going to, in Mr. Ali's instruction, include the language as a principal or as an accomplice, even giving all reasonable inferences to the state on the evidence that was presented during the course of the trial. I don't find that the evidence is that Mr. Ali, or it could be argued that he was an accomplice on the attempted murder to Mrs. Ali. And so I'm going to leave it as was set forth in instruction number 15. Mr. Leary, any exception on number 15? All right, then we are at number 16. Just a moment. Ms. Stone, on number 16.
Yes, Your Honor, element 1, same request of the state included the defendant, comma, as a principal or as an accomplice, comma, and then did an act that was a substantial step.
All right. Mr. Kading?
No objection to that.
Mr. Leary?
Based on the court's prior ruling, I think that assertion is appropriate.
With your standing objection?
Exactly.
Okay.
And then there is a typo, so it should be element 3, not 4.
Thank you.
Your Honor, we ask the defense lawyers to approach the microphone, please.
Yes. Thank you.
Sorry, sir.
All right, number 17, any issue with that, Ms. Stone?
No, Your Honor, thank you.
Mr. Kading?
No, Your Honor.
Mr. Leary?
No, Your Honor.
Number 18 is the definition of assault. And the definition was different as was provided. It appears to me that at a minimum, the first paragraph in instruction number 18, which includes a sentence that is bolded, that paragraph would be included as the definition. I'm not addressing the next two paragraphs yet. So Ms. Stone, your instruction did not have that second sentence in the first paragraph. Any objection to the second sentence?
No, Your Honor, it should have, thank you.
All right. And so just talking about the first paragraph, Mr. Kading, you proposed that language that the second sentence be included, and so you agree with that? First paragraph only, instruction 18.
I don't know that the second sentence, actually, I think it's bracketed, right? I don't know that that's something that's gonna be argued in this case. It's an offensive touching. Usually we use that in a lot of other kinds of cases.
I'm talking about the language, a touching or striking is offensive if the touching or striking would offend an ordinary person. You proposed that language. If you're not proposing it.
Looking at the instruction package, let me apologize.
Oh, that's not true.
Okay.
You did not propose that language.
Okay.
You proposed just through the end of the first sentence and nothing further. I apologize for that. That was language that was proposed by the state. They gave the entire 35.50 WIPIC instruction. And so you want just the first sentence?
Well,
Or that's what you believe is appropriate under the evidence, is what I mean?
I think that, that's what we're talking about, is a harmful touching, not an offensive touching in paragraph 1. Their allegation is that, there was actual bodily injury, so paragraph 2 talks, can I move on to paragraph 2? I'm sorry.
No, we're just talking about paragraph 1.
I don't think there was any offensive touching in this case.
Aren't you arguing that, or aren't you going to request that I give an instruction that this was discipline, or that that could be a defense? And so isn't whether or not the touching is offensive associated with, isn't that an argument related to your request that it was a
Yes.
defense?
Now that you mention that, that on the assault 4 would be a appropriate definition.
Well, all right. Mr. Leary, any objection to including the entirety of just paragraph 1, including the language that I have, that one sentence that's bolded for instruction 18, just paragraph 1?
Okay.
All right. So as to instruction number 18, the entire paragraph will be included, and of course it will be unbolded. Now, as to the second paragraph is to be given in cases involving an attempt to inflict bodily injury, but not resulting in battery. That does not appear, from my perspective, to be what the evidence suggests, and that was, that language is not proposed by defense, it is proposed by the state. So Ms. Stone, I would like to know why you would want that included.
Yes, Your Honor. Your Honor, when we talk about the assault 4, I want to make sure, because we've spent so much time during the course of this case, Fatima, that all of these injuries have occurred. So when we're talking about the assault, those additional paragraph instructions make it very clear that when the jury then moves to look at the injuries to Isaiah, try and decide what level of injuries, if they're sufficient, if there's injuries, those two follow-on instructions make it very clear that for the purpose of assault 4, no bodily injury is required. The state does not have to prove that bodily injury exists, and that helps clarify that for the jury, because like I said, we spent a ton of time talking about the nature of the injuries to Fatima, and there is obviously a significant distinction between those two. I would also indicate that Mr. Keating introduced photos that certainly look different, I think, from the states, or maybe arguably look different from the states, and I don't want them to get caught up in whether, well, we can't really see them here, or we don't see any, so it says that it's harmful, and we don't know that there's an injury, so therefore this assault 4 didn't occur. Those two additional paragraphs make it very clear that the state does not have to prove that, and that is not the definition of assault. There is no injury that is required in that case, and so I am asking that those be provided. It helps the state more fully argue that, and I think it is helpful to the jury in making that decision.
Mr. Keating?
Well, again, I mean, we have video of a punch. It seems to me that that's covered by number 1, paragraph 1.
Mr. Larry?
I would object to the last 2 paragraphs. My concern is the confusion as to, the state wants this for purposes of the assault 4, which doesn't come up until instruction 39, and looking at the to convict of 39 is they have to find that on or about October 18, 2024, the defendant assaulted Isaiah Williams. All they have to prove is an assault of Isaiah Williams in the paragraph defines assault as an intentional touching or striking of another person that is harmful or offensive. And so I think they certainly have the room to argue their theory as to why that has been committed. And my concern is that the inclusion of paragraph 2 and 3 will be detrimental and confusing to my client, who is not charged with a misdemeanor assault for.
Ms. Dunn?
I'm confused, I said I'm confused as how that would be detrimental. Arguing the law as it applies to the facts of the case would be detrimental to a defendant. Paragraphs 2 and 3 are the law of the assault. It is a definition for assault. It is clarifying information for the jury, and so it is confusing to the state how providing a correct statement of the laws, especially as it relates to assisting them for Isaiah, detrimental to Mrs. Ali when there is a clear standard for Mrs. Ali as to the nature of the injuries that have to occur, or the intent for those types of injuries to occur, whereas assault 4 is relatively silent about that. So that argument doesn't make sense to the state in terms of how it becomes more detrimental at all, let alone be more helpful to the jury.
All right. As to the third paragraph, I am not going to include the third paragraph. That is the language, an assault is also an act done with the intent to create in another apprehension and fear of bodily injury, and which in fact creates in another a reasonable apprehension and imminent fear of bodily injury, even though the actor did not actually intend to inflict bodily injury. No inference from any of the evidence in this case relates to that portion of the definition of assault. And the WIPIC 35.50 indicates that the third bracketed definition should be used if there is evidence that the actor's intent was not to inflict bodily injury, but only to create the apprehension or fear of bodily injury. And the evidence that has been presented in the light most favorable to state is the first paragraph definition of assault, that it's an intentional touching or striking, and that is the evidence that has been presented, not that there was apprehension or fear with no actual physical contact. So I'm not including 3. And I am not going to include paragraph 2 either. The WIPIC indicates that that paragraph, which indicates an assault is also an act done with intent to inflict bodily injury upon another, tending but failing to accomplish it, and accompanied with apparent present ability to inflict the bodily injury if not prevented. It is not necessary that bodily injury be inflicted. As it relates to the assault 4, there is no burden on the state to address bodily injury. It's whether or not there is, I want to get to the language. They have to prove that Mr. Ali assaulted Isaiah, defined as an intentional touching or striking of another person that is harmful or offensive. And the second paragraph is not consistent with the evidence that's been presented, and I don't believe it limits the state in any way from arguing their case or confusing the jury, because the other assault charges, which require more than just the touching or striking, are clearly set forth in the elements, and the court knows that the state can properly differentiate between the assault charges. So
Would the court consider adding the last sentence? It is not necessary that bodily injury be inflicted at the end of that first paragraph.
Mr. Kading? So she's talking about using the last sentence in the second paragraph and putting that as a last sentence in paragraph 1.
Yeah, I don't object to that.
Mr. Larry?
I do object. My concern is just, my client's not charged with misdemeanor assault, and my concern is it runs contrary to what the state has to prove for assault. I understand that there are individual instructions laying out the elements of assault too, but we're then providing them with a definition that is in conflict with that with respect to the specific. I mean, I think it gets, I would just want this to be clear that we are talking about an allegation of the assault for, and that's what that sentence applies to.
All right. To ensure, I am not going to include that sentence. I understand why the state is seeking that. Again, as it relates to the charge of assault in the 4th degree, the state's burden is to prove that there was an assault, which is the intentional touching or striking that is harmful or offensive. I do not believe that the jury is going to be confused as they go through this process and apply that definition to the different levels of assault that are alleged in this case. And I believe it actually would be a misstatement if I added that sentence to the first paragraph. I think it could be construed as a misstatement of the law by putting it together like that. All right, instruction 19. Any issues with that instruction, Ms. Stone?
No, Your Honor.
Mr. Kading?
No, Your Honor.
Mr. Leary?
No, Your Honor.
Number E?
Just changing Ms. Ali's name in element.
Oh, thank you. Yes. With that change, removing the date of birth and putting in the name, any issue with number 20, Mr. Kading?
No, Your Honor.
Mr. Leary?
No, Your Honor.
Any issue with number 21, Ms. Stone?
No, Your Honor.
Mr. Kading?
No, Your Honor.
Mr. Leary?
No, Your Honor.
All right, instruction, as I indicated yesterday, I have instruction number 22, which was proposed by Mr. Kading. He then proposed another instruction yesterday that I did actually add into my draft instructions, but it was after I had sent it to my judicial assistant to print these, and so I had not wanted to reprint everything and renumber everything. But the other instruction that was presented, the difference is that for the lesser included, it was assault in the 2nd degree or assault in the 3rd degree. And as I go through the instructions, if I give those as lesser included offenses, I would include that language in what is currently instruction number 22. So I hear argument as it relates to the request for the lesser included offenses. Ms. Stone?
Sorry, Your Honor, just to clarify, are you asking for the substantive argument on the lesser included?
Yes.
First? Okay. I think that the substantive argument on the lesser included for assault in the 2nd degree is appropriate. I believe that would be Mr. Ali's 23A.
Yes.
I think that is appropriate. I don't think that assault in the third degree, however, where it's been alleged by strangulation, is necessarily appropriate. The assault in the third degree is not a lesser included of assault in the second degree by strangulation. As the state was going through, and certainly I think minds can differ, but as I went through it last night and was looking at it in the manner that it is alleged here, I don't think it can be the argument that only assault in the third degree occurred if the jury believes the state's evidence that has been presented. I think they could believe that assault in the third degree also occurred, but not that it only occurred in this case, based on the argument that it is done as it relates to Mr. Ali by strangulation. So I don't think that assault in the third degree is appropriate in this case.
Ms. Keating?
And Your Honor, I think that third degree is appropriate in a case like this where clearly when you have kind of a mob of people and a attack from behind that was seen in this case from Isaiah, and him having a struggle with his daughter, I think it's entirely possible that there may have been a lack of recklessness or intent, obviously, which could still leave us with, well, maybe he shouldn't have put himself in that position, and it was a negligent act that caused the assault, which would have been, what happened after he was hit. And at that point, I think that an assault 3 instruction is appropriate if it goes towards culpability and mens rea, which it clearly does. If he could have known what he was doing was wrong, but didn't. At that point, he was aware of it, and maybe it shouldn't have been happening the way it happened, but it's hard to tell what any person would do under those circumstances. And I think that's kind of what the assault 3 definition gets into. What would a reasonable person faced with the exact situation, what would have happened? And I think that's where assault 3 comes in and covers it with a negligent act.
So when I was looking at this issue, your proposed language is for the assault in the third degree with criminal negligence causes bodily harm to another person by means of a weapon or other instrument or thing likely to produce bodily harm. Clearly, there's no weapon, that there's been any evidence of any weapon. I don't know, I didn't see any evidence of other instrument. Instrument is defined in the Oxford Dictionary as tool or implement. I did not see a tool or implement. And then it says, or thing likely to produce bodily harm. And of course, other instrument and thing are not defined in the WIPIX, which is why I just looked up the definition of these terms, the dictionary. And thing is defined in the Oxford Dictionary as an object that one need not, cannot, or does not wish to give a specific name to. And so
I don't know if it's helpful, I apologize for interrupting the court, Your Honor. State versus Altman very specifically says that your arms and or hands do not constitute an instrument or a thing that is actually out of Thurston County. And so insofar as that is the concern, whether arms or hands would constitute that or meet that definition, they do not. So as it
well, just let me stop you there. That's what I was getting at and asking Mr. Kading as to why he believes that this instruction would apply under the facts, because you did not argue that initially when.
I did not, I apologize, Your Honor.
Let me take a look and see just a second. Okay, I may have included a paragraph here. There's a paragraph that says, with criminal negligence causes bodily harm accompanied by substantial pain that extends for a period of sufficient to cause considerable suffering. And I think I did include that. And I may have incorrectly put in weapon or other instrument language. And I would agree, there is no weapon or other instrument.
So your proposed instruction did specifically say by means of a weapon or other instrument or thing likely to produce. And so that is what I have is, that was on the 1 page,
Right.
separate sheet instruction A. So now you are indicating that, what are you indicating your proposed language is then?
It would be a person commits the crime of assault in the third when he with criminal negligence causes bodily harm to another person with, by substantial pain that extends for a period sufficient to cause considerable suffering. And it appears that, that would be consistent with what the, medical records show. If we consider, I guess it depends on what a period sufficient to cause suffering is, and if it's 3 days, then, or 4 days that are noted in this case, then I think that would be an appropriate instruction.
And I do have an unpublished case that I think addresses that, Your Honor. Again, obviously it's unpublished, and so if that's helpful to the court, it's State versus Brown. The state's reference is Lexus, so I apologize to the court, but it's 28, well, I can print it and provide it to the court. But the file number is, oh, it looks like there's a Westlaw reference too, excuse me. 2018 Westlaw 4959959. And the request, that was a assault in the second degree case by strangulation. The proposed request for the lesser included was with criminal negligence causes bodily harm accompanied by substantial pain that extends for a period sufficient to cause considerable suffering. So what Mr. Kading has offered here, and that is a, that was a Division I case. And the court there said to be entitled to an inferior degree offense instruction on this type of third degree assault, the evidence must affirmatively establish Brown did not strangle Gun-Tao that caused her bodily harm resulting in substantial pain. The court went on to identify the evidence from witnesses who testified about the strangulation. And the court essentially said that the evidence does not show that Brown committed only the inferior degree offense of third degree assault to the exclusion of the greater offense of second degree assault. The conclusion that he committed third degree assault required the jury to selectively disbelieve parts of the victim's prior statements and her testimony. Disbelief of evidence of guilt does not satisfy the factual element of the test for an inferior degree instruction. Brown was not entitled to an instruction for third degree assault. So for those reasons, I don't think it's the third degree request is proper in this case. I would agree that the second degree lesser would be appropriate.
All right, although certainly the court is not bound by any unpublished decisions, they can be instructive to the court as the court considers different legal issues. I would like an opportunity to read this case so that I can see if it informs my decision in any way, and also I would want Mr. Kading to have an opportunity to look at that as well. And so it is 10:10, a little early, but we'll go ahead and take a recess. I know that from what Mr. Leary indicated briefly to me this morning that he has a matter with Ms. Stone, I think in another courtroom. Potentially the parties could handle that while I look at this case, and that also will give you, Mr. Kading, a chance to look at the case as well. I'm going to attempt to make this a 15-minute recess. I know the lawyers will attempt to do that as well.
Yes, Your Honor. I'll print out a copy of that as well.
Thank you.
All rise. Court's in recess.